A suppression hearing was held this week in the Idaho4 case against Washington State University PhD student Bryan Kohberger for the murders of 4 University of Idaho students in Moscow, Idaho, in 2022. In this week's hearing, the defense argued that the arrest warrant was based on incomplete, inaccurate, and misleading information in the probable cause affidavit. Quite a few issues were raised, and here are just a few that I thought were compelling. The probable cause affidavit provides the magistrate times that Kohberger's cell phone pinged towers in Pullman, Washington, where he lived, and Moscow, Idaho, where the students lived, the night of the homicides, and plots those pings on a map to suggest Kohberger's movements on the night of the homicides. However, the times provided to the magistrate were inaccurate and off by several minutes. Furthermore, the maps in the probable cause affidavit point Kohberger in the direction of Moscow, but, in reality, he was driving in the opposite direction, away from Moscow and the victims. The probable cause affidavit relied on information provided by one of the surviving witnesses, Dylan Mortensen. She claimed to have seen a man in the house and described him as skinny, white, and taller than 5'8". However, in the probable cause affidavit, the description supposedly provided by Dylan Mortensen was a man taller than 5'10" with an athletic build. The magistrate was also not made aware that Dylan Mortensen told investigators multiple times that she was drunk, had a bad memory, and was not sure if her memories were real or a dream. The FBI used genetic databases to identify potential relatives of their suspect. The FBI did not disclose the genetic database information to the defense, claiming they did not keep the documentation. This fact challenges its reliability and even its existence, yet it was stated as fact in the probable cause affidavit. There was unknown male DNA found in the form of blood on the handrail of the stairs, classified as unknown male B, and unknown male DNA found in the form of blood in a glove just outside the house, classified as unknown male D. These classifications infer there is also evidence from 2 other unknown males, classified as A and C. The magistrate was not made aware of the existence of DNA evidence from any other males. A Franks hearing is a critical judicial process in criminal cases, addressing allegations of false statements or omissions by law enforcement in obtaining search warrants. It plays a significant role by examining the validity of evidence gathered under potentially misleading pretenses and ensures constitutional rights are upheld by scrutinizing warrant affidavits. The issues raised by the defense in the suppression hearing suggest that the PCA was written with the intention to influence the magistrate to issue an arrest warrant based on the inclusion of misleading or outright inaccurate information and the exclusion of evidence that could result in the denial of an arrest warrant. The defense has requested a Franks hearing, and the judge is considering it. What do you think? Please like and subscribe. It really helps out the channel.